Okay.
All right. Good morning, everyone, and welcome to Navigating Guardianships and Conservatorships. I'm Courtney Tarver, and I'm a volunteer with AARP Alabama. I'll be your host for this conversation about guardianships and conservatorships. And we are joined today by Mr. Gaines Brake, an attorney who serves as of counsel with the law firm of Maynard Cooper and Gale, where he co-chairs the firm's elder care team. Gaines is a graduate of Birmingham Southern College. He also has a master's from the University of Alabama School of Music. His bachelor's was also in music, interestingly. And he has a Juris Doctor degree from the University of Alabama School of Law. Additionally, he was a member of WINGS, which we've got several WINGS organizations in Alabama, but this one it stands for Working Interdisciplinary Network of Guardianship Stakeholders. And he's now, like all of our presenters in this series, a member of the Alabama Commission on Adult Guardianships and Conservatorships. Each Tuesday in November, AARP is proud to partner with the members of Alabama WINGS to bring you detailed information about guardianships and conservatorships. During this series, we'll break down the information into small topics to make them easier to understand and to discuss. Please feel free to ask questions, and as you may have already heard, put those questions please in the chat, or you may raise your hand in the Zoom program where you click on reactions and then hit the raise your hand feature so that we'll know you have a question. We'd also like for you to list in the chat what brings you to this presentation. Is it your work? If so, tell what kind of work you do, if you're a caregiver, or whatever brings you to this. Today, we'll review the basics of guardianships and conservatorships and the capacity to make decisions. Remember, if you have a question, please put it in the chat or raise your hand. Now, we'll hear from our subject matter expert for today, Mr. Gaines Brake. Gaines?
Thank you for that introduction, Courtney, and thank you, Ann and Anna at AARP for hosting this very important series on guardianships and conservatorships. As Courtney mentioned, I'm going to give you a very basic overview on guardianships and conservatorships, as basic as an attorney can make it, and I've really tried. So it's not going to be hopefully too little, and it won't be too much. And I would just preface it by saying I assume that we're all from Alabama, but I don't know that. Certainly with the technology and the capabilities of Zoom and remote connectivity, you could be from anywhere if you knew about this program and registered for it. This will be, at least to the extent that I discuss legal concepts, we will be focusing on Alabama law in terms of how the state of Alabama defines an incapacitated person who is in need of a guardian or a conservator, and what that procedure looks like in the state of Alabama. However, we'll be talking about some fairly broad concepts that I would think transcend different jurisdictions, just in terms of decision-making capacity, alternatives to guardianships, less restrictive alternatives, and things that you can consider before you decide to pursue a guardianship or recommend that to someone. So I'm an Alabama lawyer. I'm licensed in the state of Alabama. So that's just sort of naturally what I'm going to focus on. I did prepare a few slides, and I will make a valiant effort at this time to share my screen, and let's hope that works. Does everybody see a slide?
Looks great, Gaines.
Okay, good. I don't know if you still see me or not, but I assure you I'm here. So We're going to talk about some legal mechanisms for decision-making assistance today, and I list here just as an overview some voluntary designations of authority before I list the court-appointed kind, because I believe that's sort of the order that these matters ought to go in terms of what can we do to support decision-making before we look to guardianship, and particularly what legal options might there be as alternatives. And we'll talk more about these things in a moment. But first, just some basic terminology on guardianships and conservatorships from the legal side. A guardian makes personal non-financial decisions for an incapacitated person. The term that the law uses, or that you sometimes hear, although it is sort of an old-fashioned term, for the person at the center of those proceedings, is a ward. Now, that's a term that we're trying to sort of get away from in modern times, but you may hear that term as it relates to a person who is subject to a guardianship. A conservator, on the other hand, makes decisions regarding a protected person's money or property. So we're talking basically about similar offices, similar jobs that often are held by the same person if a court proceeding is undertaken to appoint a guardian or conservator. But legally, there is a distinction between a guardian and a conservator, and what each one of those positions entails. So just keep in mind, on the very basic level, a guardian makes personal decisions, a conservator makes financial decisions. And I mentioned that a guardian makes these decisions or is appointed to serve over an incapacitated person. Now, we all probably have an idea of what we think that means, an incapacitated person, but since we're talking about the law and a legal proceeding, we have to operate in terms of what the law defines an incapacitated person to be. Now, I've copied here, these are the definitions that I've lifted straight from the applicable statutes in the Alabama Code. And you'll see that the definitions for each, in terms of what is an incapacitated person in guardianship and conservatorship, are pretty similar, but they're different in some very subtle ways. So in a guardianship, a court has to determine that the person at the center of the proceeding is an incapacitated person. And that means that they are a person who is impaired by reason of mental illness, mental deficiency, physical illness or disability, or an infirmity accompanying advanced age, substance abuse, or another cause, to the extent of lacking sufficient understanding or capacity to make or communicate decisions. Then under a conservatorship, the finding is similar, and we're talking about the more or less the same conditions that can precipitate that finding. But there, we're talking about an inability to manage property and business affairs effectively. So more or less the same conditions that can lead to that finding, but slightly different in what that person can't, or I guess can or can't do to support that finding. So again, here in the conservatorship context, we're looking at business affairs, financial affairs, and the person's ability to make those types of decisions versus the ability to make or communicate responsible decisions just generally in terms of a guardianship. So I'm going to skip back to this slide because I think it flows better if I talk about the incapacitated person definition before I get there. So what we're basically looking at to determine that someone is incapacitated is a cause and effect. So the cause is the mental illness or the physical disability or the chronic substance abuse, as you saw in those definitions. The effect is the inability to make or communicate decisions regarding a person's person or their property. So to further break that down, this is an individual who cannot tend to their own personal care or financial matters importantly for our discussion today, someone who has not designated someone else with legal authority to assist them, someone for whom less restrictive alternatives may have been tried and did not do what they needed to do. And most importantly, someone who has an actual need for another person with legal decision-making authority to help them, to make decisions for them on their behalf. And oftentimes we're talking about an individual who may be the victim of abuse, of neglect, or financial exploitation. So we have a legal definition that has to be met here. So in terms of a cause and an effect, the cause being a physical or a mental condition or a disability that is actually making it where the person can't make these decisions about their person or their property. So then if we know who needs a guardianship or who could qualify for a guardianship under the law, then who might not need a guardianship. A guardianship is not, or I guess the finding of incapacity rather, is not a one size fits all sort of thing. What makes another person incapacitated might not apply across the board. So generally speaking, having a physical disability or even a mental illness alone doesn't mean that you're incapacitated. Certainly doesn't mean that you may be incapacitated to the extent of needing a guardian or conservator, or that you meet that definition that I just went over. So if you're a person with a disability that does not affect your decision-making ability, you don't need a guardian or a conservator. You may not need any help at all. If you have the ability to give informed consent, then you probably don't need a guardian. Now, what is informed consent? This is a concept that generally arises in medical situations in healthcare, where a person has to be able to understand a procedure that they may need to have, or a surgery or anything that has to be done in a medical or healthcare environment. And what that means basically is a physician and a patient have a conversation. And in that conversation, the physician explains the procedure at issue, the risks associated with it, the benefits of having it, alternatives to the procedure, and what might happen if the patient didn't have the procedure. And if the patient can understand, can have that conversation with the physician and can communicate understanding of those risks, those benefits, those alternatives, what might happen if they don't have the procedure at all, then we can say that that patient has given informed consent. Informed consent does not happen by signing a document. It doesn't happen by signing an intake form at the ER. It doesn't happen by broadly granting a hospital or a healthcare institution the consent to do whatever they decide that you need. It's a process. It's a conversation that needs to happen between a patient and a healthcare provider. So it not only depends on the procedure to be done or that's offered, but it depends on the person or persons participating in that conversation. So informed consent for a very minor procedure might be easier to get than informed consent to a very complicated procedure. So there again, informed consent is not a one size fits all type of thing. Someone who can make decisions with appropriate supports also probably doesn't need a court-appointed guardian or conservator. And we're talking about informed consent type decisions, and we're talking about financial and other types of decisions here as well. And what appropriate supports look like can also differ by the situation at hand. So it's often said that we all need supports to make different types of decisions at different times, depending on what those decisions are. For example, I may have no trouble deciding where I want to go to eat on a given day, but I might need some assistance deciding what type of financial investment to make in my retirement plan, or what type of procedure I might need to fix a certain healthcare problem I may be having. So there's a continuum of decisions and decision-making supports that a person might need depending on the complexity of a given decision and their personal ability to understand and comprehend the subject matter of that decision. And those supports also exist along a continuum depending on what a person may need at any given time. And that continuum is sort of what underlies this concept of supported decision making that I'm not going to get too deeply into, but it is something that we all need to know is an alternative and is out there. It's an alternative to guardianship and conservatorship. It has various, I guess, levels of formality. In some states, it is a legally recognized alternative to guardianships and conservatorships. However, it can be used in just about any jurisdiction, whether it's legally recognized or not, because it is an informal means of support. So supported decision making basically is a concept or an arrangement that embodies all of those things I just mentioned. An informal network of supports or caregivers that is offered or provided to a person who may need some level of assistance making or communicating a decision. And when we're talking about decision making, we're talking about anything from healthcare to finances to where a person may want to live. And not only are we talking about supports to make that decision, but supports to communicate that decision to others. So a person who may not have the ability to make a decision completely on their own may benefit from just a caregiver, a friend, or a family member helping them to understand the subject matter of that decision, helping them to, in their own terms or in their own way, understand all of the alternatives that they may have, just what is involved in the decision, sort of break it down for them. And then when they feel like they've helped that person arrive at a decision, to help communicate that decision to whoever may be on the other side of it, be that a financial institution or a physician, anything like that. In terms of court-appointed guardianships and conservatorships, I mentioned earlier that there is not a one-size-fits-all in how we determine whether a person needs a guardianship or conservatorship. For those who may need a guardianship or conservatorship, there also should not be a one-size-fits-all guardianship or conservatorship. And this is a concept that is embodied in our current law, and it is something that will hopefully be expanded upon should we ever amend our guardianship conservatorship statute, which is something that's sort of in the works now. But many of us who have any experience with guardianships probably conceive of them as just this thing that you go to court and you get. It's a blanket designation of authority. It allows the person who holds the guardianship the ability to make any kind of decision, any place, any time for the person who is subject to the guardianship. There's been a movement away from this sort of one-size-fits-all appointment, and that even goes back as far as 1987 when we adopted our current Guardianship Act in the state of Alabama. And courts under that act are instructed to fashion these appointments, these guardianships or conservatorships, only to the extent necessary so that the authority of the protector, be it the guardian or the conservator, will intrude only to the degree necessary on the liberties and prerogatives of the protected person. So a court here in this statute is called upon to sort of make a determination of what the person needs in terms of what authority will be granted to the guardian or conservator. And that's sort of this less restrictive alternative that I know many of you are familiar with, that pervades all of the whole gamut of substituted decision making, whether it's through supportive decision making that I just discussed, through alternatives such as powers of attorney that I will discuss, and all the way into the guardianships and conservatorship proceedings. The notion that we only protect a person to the extent that they need to be protected, and we try to support and give agency to them to make the decisions that they can make and retain the autonomy that they can retain. In the concept of guardianships and conservatorships, the court-appointed stuff that we're talking about today, if there are limitations on the authority of a guardian or conservator, those should appear on the letters that are issued by the court. And I'm going to talk a little bit more about that, how that works in a minute. So again, continuing with the basics of guardianships and conservatorships, the procedure for how you get a guardianship in the state of Alabama begins with a petition that's filed in the probate court in the county where the incapacitated person lives. When that happens, and I think I'm correct that there will be a whole presentation later on in this series devoted to the court procedure for appointment of guardians and conservators. So I'm not going to dwell on this too much, but just so you understand from the basics how this works. The court sets a hearing date. There's notice that's given to the person alleged to be incapacitated. In other words, the person who is sort of at the center of the proceedings has to receive notice. Their family members also are entitled to notice of that petition. And then the court appoints a physician, a representative, and a guardian ad litem, whose job it is basically to assess the alleged person at the center of this petition, to assess them and the environment in which they live, and the petitioner who has filed the petition will talk to these people and submit findings to the court to help the court determine whether the person meets that definition of an incapacitated person that I mentioned a few minutes ago. A hearing is then held to determine if the person is incapacitated under that definition, and if the person needs a guardian or conservator to assist them, to make decisions for them. And that hearing can involve testimony by witnesses, documentary evidence. It will certainly involve review of the physician's assessment that was done and reports from the court representative and guardian ad litem. If the petition is granted, I should have said in my bullet point there at the bottom, if the petition is granted, the judge will issue letters of guardianship and or conservatorship, and then the guardian or conservator would proceed to take control of the person's decision-making and their finances. I mentioned earlier that the guardian and the conservator are different offices. They very often, if both are appointed in the same proceeding, they very often will be the same person who is appointed to those roles, but they do have different duties. And I'll mention here just a few as examples of duties for guardians and conservators. As I mentioned, the guardian has responsibility for the person, their personal decision-making, and that would include arranging for medical care and making decisions. So I mentioned earlier that process of informed consent, where a doctor meets with the patient, talks about the procedure, and explains its risks and benefits and its alternatives, and the patient gives their consent to have that procedure or to not have it. When there's a guardian, the patient doesn't give that consent anymore. The ability to do that in a typical guardianship has been transferred to the guardian. So if a decision is made or a conversation is had between a physician and a guardian, then the guardian, in that case, under the law, would be the one to tell the physician whether or not to perform that procedure. However, the guardian should, and even under the law, is required to talk to the physician, the patient, to the person subject to guardianship, and get their opinion, to include them in that decision-making process. So while legally the guardian has the ability to make that decision, and sadly, in some cases, that informed consent process doesn't even involve the patient, although it should, the guardian can make that decision, make that ultimate decision, and the healthcare provider can rely on that decision from the guardian as the legal decision of the patient. So that's, I pause a little bit to talk more about the healthcare context, because it's one of the most important and I think significant ways that a guardian can act on behalf of an incapacitated person, but also as a good example, I think, of how the guardian should continue to try to include the patient, the incapacitated person, in that decision to the extent that they can be included. Other roles or other authority that a guardian has is the ability to decide where the incapacitated person lives, visitors that they have. Other protective measures can be the responsibility of the guardian. So for example, if the person doesn't have a conservator yet, if they weren't appointed a conservator, but they later would maybe need a conservator, then the guardian can petition for that. But otherwise, the guardian's authority does not extend beyond the care of the individual. Certain financial matters are within the guardian's authority if they're directly related to care, but much beyond that, a conservator will be needed to make those decisions. Conversely, a conservator's authority generally involves receiving income, paying bills that the protected person may have, managing financial accounts, hiring, firing financial experts, attorneys, dealing with real property, resolving disputes, managing a person's estate that, for example, that may be necessary to qualify for Medicaid. That's a situation that often arises that may be a reason to apply for conservatorship if a person needs to qualify for Medicaid and has excess resources that need to be disposed of, but doesn't personally have the capacity to sign a deed or to spend down their assets. A conservatorship may be needed in that situation. And I would say that would be a perfect situation for a limited conservatorship if we're talking about a situation where a person only needs assistance to spend their estate down so that they qualify for Medicaid. That's a good example, I think, of a situation that may only need a very narrow appointment. So if I were an attorney and somebody came to me asking for assistance spending down to qualify for Medicaid, and I met with the person and determined that they didn't really need much assistance doing much else, but yeah, maybe they can't sign a deed, that's a perfect example of something that you might ask the court to limit, or a way that you might ask a court to limit the authority of the conservator to preserve the autonomy of the individual, so that all you are doing is addressing that one very targeted need, which is a financial need. So again, here, financial decision-making is made by a conservator. Personal decision-making is done by a guardian if one has been appointed. So we've talked about situations that might warrant appointment of a guardian. When might a guardian not be necessary? I alluded to some of these situations earlier. If a person can make decisions with accommodations, whether that's an accommodation sort of like a supported decision-making arrangement, whether it's some sort of assistive technology for communication, those are situations where a person may have one of those conditions that the law outlines as the cause, but the cause may not be accompanied by the effect. And if the effect can be remedied by some sort of accommodation, then you don't have that cause and effect that would be necessary for a court to appoint a guardian. So you may not be able to eliminate the cause, although certain conditions can be temporary and can resolve, but accommodations may help you eliminate the effect of that disability or of that illness. And we really should be looking for those accommodations in situations where a person may just need assistance making or communicating the decision. Guardianship also may not be necessary if a healthcare power of attorney or if necessary, an advance directive for healthcare had been executed by the person. Similarly, a conservatorship may not be necessary if we have financial accounts at issue that can be accessed legally by someone else. So if there are financial accounts that are jointly owned and the other co-owner has capacity and can access those resources, then we wouldn't need a conservator to get to that money. Or if there are accounts that just have an authorized signatory, for example, a checking account that has someone who has access to write checks, we wouldn't necessarily need a conservator to access that account. A financial durable power of attorney can also provide the authority that may otherwise be needed by a conservator to make decisions. And I saved Social Security for last because in many cases, a person's only income and in some cases only resource is a Social Security income stream or a Social Security benefit. And Social Security has its own procedure in place for appointing someone called a representative payee who can receive a person's benefits on behalf of the beneficiary and then has the responsibility to see that those benefits are spent for the beneficiary's needs. And that is a procedure that's done completely within the Social Security Administration. It's separate and apart from the state probate court guardianship and the conservatorship process. You don't have to be a conservator to be appointed someone's representative payee. The legal standard is different. It takes less time and generally doesn't cost anything when compared to a guardianship conservatorship to get that done. So the representative payee is probably the most classic example of an alternative to a conservatorship where a beneficiary's only resource or income is that Social Security benefit. And that's something that Social Security provides a lot of information on how to do it. It's generally not something that you need a lawyer to do. They try to make that process easy on everyone if that's needed. So if you have a guardianship or conservatorship, how do you get rid of it? Well, in most cases, you don't. More often than not, once a guardian or conservator is appointed for someone, they're probably going to have it for the rest of their life, unless they have the capacity, the protected person has regains the capacity or has the agency to challenge either the appointment or to find a way to petition to have their rights restored later on. Now, it's not a foregone conclusion that they last forever. It's just, unfortunately, what tends to happen most of the time. Guardianships and conservatorships are designed to be removed in the law. When a person regains capacity, it's just not typically a very easy process. And a person who regains capacity has to have, obviously, access to the courts to file a petition or access to their own attorney who they can file a petition to restore their rights. Obviously, the guardianship or the conservatorship would end on the death of the ward or the protected person. And otherwise, it would require going back to court to get that removed. Incapacity or the death of the guardian or the conservator doesn't terminate the guardianship or the conservatorship. It only terminates that person's authority, obviously. And if that were to happen, the court would appoint a new guardian or a new conservator if that person became unable to serve. So another reason to consider alternatives wherever they can be considered is that guardianship and conservatorship, once they are imposed, are very difficult to remove. And probably the classic example of that all of you have heard of lately is the Britney Spears guardianship, which has sort of ignited a firestorm in advocacy circles for what not only was involved in having a guardian appointed in that case, but what Britney has had to go through to try to get her guardian removed. So bear in mind that if you recommend a guardian or a conservator for someone, if you tell a family they need to pursue a guardianship or conservatorship, not only should you first consider alternatives to that, but you should also consider how difficult that is to remove, and the fact that once it's imposed, not only will the person probably get more of a guardianship or conservatorship than she actually needs, but he or she may have it for the rest of their life. Some problems I've listed here with guardianships, just generally, a guardianship is the most intrusive alternative for what may be a small problem. And generally, when a petition is filed for a guardianship, the petitioner typically will ask for full authority, whether or not they really need it. This is referred to as a plenary guardianship, and plenary guardianship is granted basically over every aspect of the ward or protected person's life, even when that may not be necessary. It's just typically what is done in the probate courts of Alabama. And the reasoning that's sometimes given for that is that it's such an expensive process, it's such a long process. The petitioner and the court thinks that, well, if there's ever a possibility that plenary authority will be needed, we're just going to go ahead and grant it now so that everybody doesn't have to come back to court, which is, I guess, a sort of overly practical solution to a problem that may be temporary and a problem that may not even really exist. Even though the law tells courts, it tells petitioners and parties that least restrictive alternative is preferred, what often happens in practice is a plenary guardianship is granted over every aspect of a person's life, even if it's not necessary to address the specific issue that person needs assistance with. And the reason why it's overreaching and the reason why it can be so detrimental and devastating in some cases is that the ward, the person subject to these proceedings, loses their autonomy, loses their decision-making, loses their ability to control even the most basic aspects of their life. And I've included this quote, civil death is how some have described the effect of a guardianship, where a person may have the ability to make some decisions on their own, but once a guardianship is imposed, legally loses the authority to make those decisions. And I'm talking about the plenary guardianship. It's an expensive process, and I've listed dollar signs here by everybody who gets paid in a guardianship or a conservatorship. Lawyers get paid, doctors get paid for evaluations, guardians ad litem are paid for their time and expenses. The court gets paid filing fees, hearing fees, and in the case of a conservatorship, a bond is required to protect the property of the protected person, which is basically an insurance policy that has a premium based on the value of the person's estate. Another thing to consider is that guardians and conservators don't really have to have any particular qualifications to be appointed. And that's a good thing and it's a bad thing. It's a bad thing because we don't have any minimum expectations or minimum qualifications rather of these people. In some cases, it's a good thing because there just may not be very many people who are available and willing to serve. So we can't impose too many qualifications, but nevertheless, if you're a family member appointed as a guardian, you don't have to have any particular level of experience taking care of someone else, or any particular level of sophistication or experience taking care of somebody's money. So the only thing that may protect the person in those cases is a bond for the conservator, and the requirement that the conservator account or basically submit a report every few years to the court on what they've done with the person's money. Probate courts in Alabama also have limited resources. They don't have the ability to really monitor guardians and conservators the way that they may like to, or that we would like for them to. Another problem with guardians and conservatorships is that they're sometimes the cause of great family controversy and family strife. And the situations that I frequently see in my practice are just disagreements over the care of an older person, where that person should live, how their assets should be spent. And if those disagreements, if they're among family members, reach the point where they can't be resolved informally, then someone might file for a guardianship solely so they can take control and make decisions about that person and their resources. That person may not need a guardian or a conservator personally, but family members may impose that on them just so that one side wins control versus the other. And I mentioned earlier that once imposed, they're very difficult to remove. So we talked about supported decision making, which is an informal way to help a person make decisions. There are voluntary designations of authority that can be made by a person that can avoid guardianships or conservatorships or the need for those things. Durable power of attorney grants the authority to transact financial business on behalf of the principal, who is the person who signs the power of attorney. A healthcare power of attorney grants authority to make healthcare decisions. And an advanced directive is similar to that healthcare power of attorney, but covers end-of-life healthcare situations and provides another person called a proxy the authority to enforce the decisions that have already been made in advance by the person who signs that document. All three of these things together, if they're done by a person who has capacity, can just about eliminate the need for a guardian or conservator, because they cover all of those areas of decision making that would otherwise be made by a guardian or conservator. However, they have to be done by a person who has capacity themselves to understand and sign those documents. So I deal most frequently with older people, so I counsel my clients to make those decisions and to sign those documents if they can early, because incapacity sometimes is associated with age. As people age, they may begin to gradually lose the ability to make certain types of decisions. But if they have signed these documents before that cognitive decline begins, then they may have eliminated the need for a guardian or conservator later on if they reach the point of needing one. The advantages of these designations are a person who signs a power of attorney or a healthcare power of attorney gets to choose who gets to make their decisions for them, as opposed to having a court decide through a guardianship or conservatorship proceeding. They get to choose. And in those documents, they also get to decide the scope of authority that person has. In other words, they can specify exactly what types of decisions they want that person to make and leave out or omit the types of decisions they don't want that person to make. They can also decide when the power of attorney is effective, whether it becomes effective immediately when they sign it or springing, which may be tied to their later cognitive decline or incapacity. And as long as they retain capacity, the person who signs a power of attorney can terminate it or revoke the authority. And I emphasize, as long as they retain capacity, they can revoke it. So that they have to have the capacity to sign the document. And they also, if they later change their mind, or if the agent doesn't work out or turns out to be a poor choice, then they have to have the capacity to revoke that designation. And if a guardian or conservator is ever needed, the power of attorney in Alabama allows the principal, the person who makes it, to say who they want that guardian to be, to express a preference. Some problems with these types of voluntary designations is that, as I mentioned, you have to have a competent principal to establish or revoke it. The agent should be trustworthy. That goes without saying, but a lot of times people who sign powers of attorney don't know for sure whether they've made a good choice until the agent has acted or has made decisions, and in some cases has made poor decisions or even criminal decisions. So choose wisely. If you're signing a power of attorney, you need to pick a good agent. The agent is the person who's carrying out your wishes, who's making those decisions for you. Someone who you trust implicitly should be your agent. Unlike a guardian or conservator, the power of attorney doesn't have any overarching judicial oversight. A court is not looking out for the person who signed a power of attorney on a continuing basis like they are a guardian or conservator. And if problems arise, you're looking at having to go in and potentially sue the person who holds the power of attorney, the agent, for mishandling your finances, so that you're having to fix the situation after it has already happened. But in terms of advanced planning through these types of documents, and here again, I'm sort of approaching this from someone who works with older people more often than not, but these considerations can apply for people with intellectual disabilities, with developmental delay, anything that might call for a designation of authority, or for someone who may need assistance with decision making. These are community or family type situations. These are conversations that need to be had between the person at the center of the proceeding or the document and their family. They should talk about the needs, desires, and values with family and caregivers. The person who's making these decisions needs to, as I mentioned, choose their decision maker wisely. They need to name alternates if they can for the person making decisions in case that first person is unable to help. And they need to, where they can, put those choices in writing through a durable power of attorney or a power of attorney for healthcare. And then monitor that plan and make adjustments as needed in the future. So it's not only are we talking about a one-size-fits-all plan, but we're also not talking about a rigid plan that has to stay in place forever. A person's needs may change in the power of attorney context, and may call for some different type of authority than what was originally granted, or if someone regains their capacity or changes their mind about the POA, then they can revoke it with capacity. And the same goes for those healthcare decision-making regimes. But I think the takeaways here, and I'll stop in a second and allow questions, are in terms of least restrictive alternatives, we don't want to help any more than help is needed. We don't want to intrude into the autonomy of the person at issue, and we want to at all times support their ability to make their own decisions, their ability to express preferences in terms of where they live, who they see, how their resources are spent for their own benefit. And how we do all those things depends on the person. This is an individual assessment that's made in the beginning, and it's continuously made throughout whatever process we're talking about. And it's important even when a guardianship, be it a limited guardianship or a full guardianship, is imposed, that if you are the guardian, you involve that person in their own decision-making to the extent that they can be involved, even if you're the one who makes the ultimate decision. That's embodied in the law. It's a concept that has been given more credence in recent years and will continue to evolve and be embodied in future law in a more formal way. So we should be ready for that, whether we're guardians, whether we're family members or providers. We need to try to reinforce decision-making capacity that's different across the spectrum. And we need to acknowledge the abilities that people have to make their own decisions along a continuum based on the complexity of those decisions and that person's ability to be involved in their own decisions. But that's guardianships and conservatorships and alternatives from a basic level. And I'm happy to take your questions or comments.
Hey, Gaines, thanks so much. This is Anna, and I have a few questions I've collected through the chat. So I wanted to go ahead and hit you with those, I guess. That's
Okay.
all right. First, we just had somebody ask if they could get a copy of your PowerPoint slides, and
Certainly.
I can send those out.
That's an easy question.
Terrific. Always start with a soft one. Can the guardian and the conservator be the same person?
Yes, they don't have to be, and they don't have to be appointed at the same time. But yes, and that's more often than not what happens. When a petition is filed, it's often a petition for both the guardian and conservator, because if a person is incapacitated, they may be incapacitated to the point of not being able to make either personal or financial decisions. And if that's correct, if that's found to be the case by the court, then the court can appoint a guardian and conservator. And if it's done at the same time, it's almost always going to be the same person.
Just as an aside, sometimes families like to have different people just as checks and balances, though, depending on the situation. Is that right?
You're right. You're right. I'm glad you mentioned that. And that is also true with powers of attorney and healthcare powers of attorney. Healthcare power of attorney is a healthcare decision-making document, and a durable power of attorney is a financial document. In the same way that guardianships cover personal decisions and conservatorships are for financial decisions, there may be people involved in a person's life who are more suited to make either of those decisions. And as a result, maybe better choices for guardians. The example I often give when I'm talking to clients about doing powers of attorney is that if you want to involve both of your children, for instance, if someone has two children, you might choose to have your daughter, who is a nurse, be your healthcare power of attorney, and your son, who is an attorney or a stockbroker, hold your financial power of attorney, or vice versa. So they're different jobs, and they can be split up amongst different people if that's appropriate. But they often are held by the same person.
Does the conservator or guardian have to live in the same area as the protected person?
They don't have to. Generally, to do the most effective job and to fulfill their duties to the court and to the guardian, they need to have easy contact or the ability to be a part of that person's life. So you need to live close to the person that you're appointed to take care of. And if, for example, you lived far away and you petitioned to be somebody's guardian, and someone else came in as a part of that proceeding who lived next door to the guardian, who is a family member and who is just as appropriate a choice as the petitioner, that person who lives next door might convince the court that they should be that person's guardian instead. So it's sort of a practical consideration, but generally the petitioner is going to have to convince the court that they're going to be there to take care of that person if they're the guardian, or to look after that person's finances if they're the conservator. So the closer you are and the better you're able to be a part of that person's life, probably the better job you're going to do, and the more likely you are to get appointed.
Okay, we've got a couple more. How hard is it to end a conservatorship if the condition of the person improves, such as a medical condition that has resolved, and the person is now able to make decisions for themselves? Well,
as in any legal proceeding, if all parties agree that something should be done, it will probably be done. The situations that can make it difficult are obviously if there is disagreement. And I go back to the example of Britney Spears. Obviously, her father did not want to stop being her guardian. Initially, I think they reached some sort of agreement. But if you have a conservator or a guardian and you feel like you no longer need that guardian or conservator, if that person doesn't agree with you, then it's going to be hard. And if that's the case, then you're going to need some legal advocacy and hopefully an attorney who can help you file a petition to end that conservatorship. And you will have as the protected person the burden of proving to the court that you no longer need that guardian. So it can be very difficult for a person to end their own conservatorship if there's not agreement to do that.
All right. It says, question, someone allowed their mother to be her power of attorney and sign the advance directives and other paperwork while in the hospital. Now she is out and says her mother can't tell her what to do. We never got anything saying she can't make decisions for herself, but she says she can. No court order, and no one wants to follow through to do so.
Okay. So the question is
if someone, I guess, designated a POA while she was in the hospital, but now she's out of the hospital. And that's a whole nother webinar, isn't it?
That's a pretty tricky one there. I mentioned earlier that any of those documents can be revoked by a competent principal. And it can be difficult, though, if you have a what I would call a rogue agent out representing themselves as as still having authority. What I have done in some of those situations, and there's definitely not a one size fits all here, and I wouldn't take this to the bank. I guess that's kind of a pun, but maybe you probably would take it to the bank in the sense that you want to make it known, if you have the ability to revoke that document, you want to make it known to the agent and to anyone that the agent might deal with that you have revoked it. Now, you're probably going to need an attorney's assistance to do this, but not necessarily. If you want to make sure that it's done as well as it can be done, the person who's just gotten out of the hospital probably wants to see an attorney. That attorney may counsel them to sign a revocation if the attorney feels like they have the capacity to do that. That revocation can be filed in the probate courts to give notice to the public that the POA has been revoked. But I would probably also try to get in touch with that agent who is acting under the POA, and also to any bank or institution that person may still be representing themselves as the agent, and let them know that they no longer are. I'm not sure I'm answering the right question.
Well, and I was going to say, because that, I think, particular one came from someone with an agency to check with their office of legal counsel to clarify their role or the steps that they need to follow to be safe. They have that opportunity. I also have a question that asks, is there a list of attorneys willing to serve as conservators? How do you find someone to serve as a conservator? Or how, I guess that's the best way to put it. I'm not aware of any list.
It depends on where you are. Some counties, particularly larger counties in Alabama, will have a public guardian or conservator who the court can call upon if there's no one interested or appropriate or qualified to serve. In counties that don't have that public person, the probate court may know, or they may have, I don't know if you would call it a list, but they may have people that they could call upon,
Okay.
to serve in those roles. But it's a good idea if you're petitioning to try to have that person identified in advance, just so you know that you have an appropriate and qualified person. Because another consideration is that for guardians and conservators, they're entitled to be paid for their services out of the estate of the ward or the protected person. Most family guardians and conservators, I shouldn't say most, but oftentimes family guardians and conservators, like a spouse serving for another spouse, is not going to take any money out of the estate to do that job. So that's another consideration, as a purely financial one, to try to find someone who's close and as a relative may be willing to do that work without compensation.
All right, here's our last question, and then I'll hand it over to Courtney. It says, I'm gonna read the question or the post. It's been my understanding that the proxy is what seals the power of attorney and prevents the person from taking control of a person that is not incapacitated. Often power of attorneys are done before a person becomes incapacitated. Can you speak on powers of attorneys and proxies versus guardianships and conservatorships?
I did talk about that. That may have been an earlier question in the presentation.
Okay.
A proxy is a term of art that exists in that advanced directive relationship. I don't know if that person is using that term in that context. A proxy is generally a healthcare decision maker, and appointed either through a healthcare power of attorney or an advanced directive if it's an end-of-life decision-making situation. The power of attorney for financial matters is over, the business affairs of a person. And those are both things that can be done by a competent person that would largely avoid the need for a guardian or conservator, and should be done if there is the ability for them to be done. And again, that's a determination to be made by an attorney who is assisting with a power of attorney, or a healthcare provider who may be encouraging or helping someone fill out an advanced directive. If there is any way for those documents to be explained in a way that a person can understand them, and that person can grant that authority and sign those documents, those can eliminate the need for guardians and conservatorships in many, many cases.
They can be written more specifically, right? And
Exactly.
can limit what rights you're
limit.
giving over.
You can decide in a power of attorney what sort of transactions you want help with, and if you haven't said help me with everything, then you have a limited appointment that only applies to certain things. Same is true for those healthcare documents. You can designate the types of care that you want to receive, and grant the proxy only the authority to provide informed consent to those types of care.
Okay, perfect. Okay, thank you, Gaines. Courtney, I'm handing it back over to you.
Thank you, Anna. And we especially want to thank Gaines Brake for his outstanding presentation today. He provided us with lots of good information. For those who may want to follow up and get brief summaries of what Gaines has talked about, we're putting in the chat links. I know there was one to the Alabama Wings website where you can go and see videos about the basics of guardianships and conservatorships. Also, there is another one about capacity, which are the topics that Gaines spoke to today. That will help you, and you can just search in a search engine If you don't pick this up out of the chat links, you can search in a search engine, Alabama Wings and Guardianships, and it will pull up the website for the Alabama Supreme Court Commission on Adult Guardianships and Conservatorships. And there are other videos that cover some of the other topics that we will have later on in this series. So please do so. In addition, we want to thank everyone for joining us for today's session. We will also on next Tuesday at 11 discuss 3 other topics: planning ahead to avoid guardianships, powers of attorney in more detail, and abuse, neglect, and financial exploitation. Thank you for joining us today.